If I could get just 1 rand for every time somebody asks me, why isn't Jacob Zuma wearing an orange overall, the amount of money that would accumulate from those questions would be enough to enable me to retire very gracefully to a villa in the south of France. Let's try and unpack why he is not yet in jail and whether he is going to be in jail anytime soon. We all need to remember that the Zondo Commission of Inquiry is not a court of law. It's an inquiry that has been appointed rather unusually as a consequence of the initiative of the former public protector, Thuli Madonsela, who, investigating complaints from the Democratic Alliance and from the Jesuit priests, came to the conclusion that there was just too much going on for her Chapter 9 institution to ever have the resources, the budget, the skill, the staff to unpack the complaints properly. So she dealt with the complaints by calling for a commission of inquiry to be appointed, and because she could see that Jacob Zuma was involved, and it is normally the job of the president to appoint a commission, she especially asked that the Chief Justice be given that task. And the Chief Justice acquitted himself of that task by appointing his deputy, Judge Justice Raymond Zondo, to chair the inquiry into state capture. And as we've spent about R1 billion of taxpayers' money on the inquiry, it's very clear that Thuli Madonsela was correct in her assumption that her Office of the Public Protector budget would not have been able to bear the fees of the senior counsel and the experienced investigators that have gone into the work of the Zondo Commission of Inquiry. But so far, other than a monologue that he delivered during 2020, the president, the erstwhile president, Jacob Zuma, has avoided giving evidence to the inquiry and has indeed walked out of the inquiry in November 2020 with the excuse that he considers that Judge Zondo is biased against him and will not give him a fair hearing during the course of his interrogation before the inquiry. Using that excuse, he has simply not appeared, and when the commission decided to approach the Constitutional Court to compel him to appear, to order him to appear, as the lawyers like to say, he simply ignored the papers that were served on him and said that he is not afraid of going to jail and that he will not be participating in the litigation that was started. Now, if we bear in mind that a commission is but a tool of the executive branch of government, and that the judge sitting in the commission is not sitting in his judicial capacity, he's sitting in an investigative capacity, and his job is to find out what the facts were and to make such recommendations as he deems meet in relation to addressing the issues that gave rise to problematic facts. Now, Judge Zondo has heard a great deal of evidence, including evidence from 40 different sources that all implicate Jacob Zuma in some way in the capture of the state, or the attempt to capture the state, during the 9 wasted years that he occupied the West Wing of the Union buildings in Pretoria. When faced with this recalcitrance on the part of Mr. Zuma, the Commission decided, in its wisdom, that rather than taking the litigation through the lower courts, and you could even start in the Magistrates' Court if you wanted to, or in the High Court, with appeals, in the case of the Magistrates' Court, to the High Court, and then to the Supreme Court of Appeal, and eventually to the Constitutional Court, they decided there wasn't time for that, and they approached the Constitutional Court itself in the interests of justice, and because of the urgency of getting Mr. Zuma to comply with his summons to attend at the Commission before the Commission wraps up in June this year. The decision to litigate civilly in the Constitutional Court was probably the only practical way to get to finality, because Mr. Zuma is known for what is called his Stalingrad strategy, in terms of which he fights the issues house by house and street by street, as was done in the Battle of Stalingrad in World War II. So, having decided that he would not be participating in the previous round of the litigation in the Constitutional Court, Mr. Zuma sat back and proceeded to make all sorts of critical comments about Deputy Chief Justice Zondo and the Constitutional Court and the judiciary in general. When he did not appear after the court had ordered him to appear on the 15th of February, the management of the Commission decided to return to the Constitutional Court and to apply for Mr. Zuma to be held in contempt of court and to be incarcerated for his contempt. And as appeared in the argument and at the end of March, the attitude of the Commission is that it's very clear that Mr. Zuma is not going to come, and that the questions that the Commission would have liked to ask him are not going to be answered, that the thrust of the Commission's latest attack on Mr. Zuma is simply to punish him for being in contempt of an order of the highest court in the land. There is no further effort on the part of the Commission itself to coerce Mr. Zuma to come to court, and the sole purpose of the application argued at the end of March was to punish him for being in contempt of an order of the Constitutional Court. And as was explained very lucidly by counsel for the Commission, it is simply a matter of being able to prove that there is an order, that the order has not been complied with, and that the person so ordered has been made aware of the order and despite that is not complying. And once those are proved, which was easy in this case, the onus is then on Mr. Zuma to explain that he is not in compliance because he does not intend to be in contempt of the court. Now, the one aspect that he raises is that the summons is not in due form, but he never puts any meat on that bone, and he doesn't seem to be pursuing that in any way, shape, or form. The other is that he continues to complain that Deputy Chief Justice Zondo is biased against him, and he has created review proceedings. He's launched review proceedings in the Gauteng High Court with a view to having the decision of Deputy Chief Justice Zondo not to recuse himself set aside by the court. And Mr. Zuma seems to think that because that review is pending, he is entitled not to attend, at least until such time as the review has been finally determined, something that will happen long after June 2021. Of course, the legal position there is not quite as Mr. Zuma would like us to believe it is. It is in fact the case that unless and until a person in his position who has a review pending in the High Court is able to persuade a court to give him a temporary interdict restraining the commission from hearing his evidence until the review about the recusal is finally determined, he is not entitled to rely on the pending review proceedings as a basis for saying that he is not intentionally flouting the decision of the court that he attend during February of 2021. The difficulty that Mr. Zuma also faces is that he has been rather noisy on social media and with releases to the press about how poorly he's being treated. He's playing his usual victim card. He feels that the judges are against him and that no court can give him a fair hearing, and that he is in a position where his decision to not give evidence is justified in law, and he seeks to rally his troops around the notion that he is being treated in a manner that is not in accordance with the rule of law, or is the product of what he calls a counter-majoritarian tendency. I think we need to unpack why what has happened to Mr. Zuma is both in accordance with the rule of law, and that his counter-majoritarian tendency is a political excuse that simply does not hold water in a constitutional democracy under the rule of law. So let's look first at where Mr. Zuma sits as far as the rule of law is concerned. There we need to understand that he has chosen not to participate in the proceedings in the Constitutional Court, both in the first round when he was required to give an explanation for his failure to attend and simply did not file papers at all, and also in the second round when he was required to come and explain why he should not be punished or possibly coerced for not attending in accordance with the court's order. And there was some debate during the hearing of the second round of the Commission versus Zuma in the Constitutional Court as to whether he should simply be punished or whether he could be coerced into attending. Now, the way that coercion would be effected would simply be to use the device of a suspended sentence, suspended on condition that he attends and gives his evidence to the Commission as required by the Commission. And remember, he has no right to remain silent there, but he does have the privilege against self-incrimination, which he can invoke when so advised and upon proper grounds for so invoking. He clearly doesn't want to go down that route. He would prefer not to go at all, and has let it be known that he'd rather go to jail than voluntarily participate in the workings of the Commission. So having taken him seriously on that, the Commission has come to the conclusion that there's no point in trying to coerce him to come because, as Council put it rather colourfully, he will just make the Commission into a circus again, which I think is almost a racing certainty. In relation to the participation of the amicus curiae, did not argue the case but put in heads of argument. There was a suggestion by the Helen Suzman Foundation that it would be appropriate to give Mr. Zuma a suspended sentence on condition that he cooperate with the Commission, that he answer the questions that are put to him, and that he invokes his privilege against self-incrimination when appropriate. But the Commission itself says no, it is not trying that avenue and did not ask for a suspended sentence on condition that Mr. Zuma complies with the order of the court that is the next step in the proceedings. So having reached the point of exasperation at which it is clear that the Zondo Commission does not want Mr. Zuma to come anymore, but does want him to be punished, we are left in a situation where he simply hasn't given an account for the role he has played in the capture of the state. He simply hasn't explained away the evidence that has been given against him, and he has declined to put a contrary version to the Commission by way of evidence either on paper in an affidavit or by gracing the witness box in the Commission. That leaves the Commission in the situation where it has uncontroverted evidence from 40 different sources implicating Mr. Zuma in the commission of many criminal offences and in the project of state capture, which is one in which the organs of the state, the activities of the public administration, are repurposed to serve the ends of those involved in the state, the capture of the state, and not to serve the public weal, which is what the state is meant to do. In relation to the question of the appropriate punishment for Mr. Zuma, the Commission has asked that he be incarcerated for 2 years, and the period of his incarceration is really something that is in the discretion of the judges who are sitting in the Constitutional Court. Some legislation, which is not relevant to this case, takes the punishment all the way to 15 years, whereas other regulations and laws seem to suggest that the minimum would be 6 months and sometimes with the option of a fine. So it is a unique case. It is a case in which the Constitutional Court will be grappling with the issue that arises when a former state president who has taken an oath to uphold the Constitution and the rule of law is acting in a manner which is clearly in breach of both his constitutional duties and in breach of the rule of law. My guess is that the Constitutional Court will indeed find that Mr. Zuma is in contempt. There is no other finding that presents itself. They may be tempted to treat the matter as one that isn't urgent and kick the can down the road. But the urgency of the matter is not that Mr. Zuma will not give evidence and is not really being asked to give evidence by the commission anymore. The urgency of the matter is that the former president is displaying an attitude towards the highest court in the land which can really only be described as flagrantly contemptuous. And that is something, as Winston Churchill would have said, up with which the court should not put. And the likely outcome is that the court will order the Minister of Police and the South African Police Service to arrest Mr. Zuma and to take him to a place of incarceration, which would be a prison in the vicinity of Nkandla, where he must be kept for such period as the court deems meet. There may well be resistance to that, and there may well be the dancing in the streets and waving of placards that the RET faction of the ANC seems to be fond of. But if it wasn't bad weather that kept crowds away from court, it seems that those who are prepared to come out in support of Mr. Zuma are in a small minority, and that minority is shrinking. The other aspect that we need to talk about is the claim of the counter-majoritarian tendency. Mr. Zuma clearly does not understand that the South African Constitution is in place in order to protect minorities. It has a Bill of Rights that gives each and every individual in the country rights which the majority are not allowed to trample. And to seek to rely upon counter-majoritarian tendencies is really a mistaken approach, of a misunderstanding of the law. Some of you with long memories will recall that Mr. Zuma once told the leader of the opposition in Parliament that the majority has more rights than the minority. Well, he's quite wrong about that. Everybody has equal rights in South Africa. We need look no further than Section 9 of the Constitution to see that that is the case. So the political side of it, I leave to those who are clever about politics. The legal side of it is that Mr. Zuma is in contempt of court, and that Mr. Zuma must be punished in the way that the Constitutional Court regards as appropriate. We have a reserved judgment on that. They will obviously want to consult each other and look carefully into the comparative law that the Helen Suzman Foundation placed before the Constitutional Court and at the arguments presented on behalf of the Commission. And we can expect, I would think, fairly shortly, certainly within a month, that there will be a judgment of the Constitutional Court, and that it will involve a nice orange jumper for Mr. Zuma, Whether it comes with the possibility of a suspension remains to be seen. The amicus was asking for that, but the Commission has washed its hands of ever getting any sense out of Mr. Zuma. I do hope that the questions about the orange do not stop, because unless and until South Africa has anti-corruption machinery of state that is constitutionally compliant, this type of case is likely to arise again, and the need to end the culture of corruption with impunity that is abroad in the land is urgent. It's a need that needs to be filled quite soon.